Welcome to Missouri Law Matters, a podcast all about your Missouri courts. My name is Matt Hamner. I'm a judge on the Southern District Court of Appeals in Springfield, Missouri. Thank you for being with us today. If you've enjoyed the podcast, don't forget to like and subscribe to Spotify, Apple, or on YouTube. Check out all those channels connected to the Missouri courts. I have a fabulous guest joining me today. It's someone who may look familiar to those of you who have been watching or listening to other episodes of the podcast. Producer Michelle is back with us today. Just a couple of months ago, we did an episode whereby Michelle came on the pod and asked me some questions that she had collected in her travels around the state about various things. And we got a lot of positive feedback to that episode. And so because of that, we thought we had a little break in our schedule that we would do that again and answer some more questions that she has collected from her travels around the state. First off, Producer Michelle, welcome to the show.
Thank you.
Thank you so much for being here today. You are doing well. No, I only get to see you when we record these pods, so I'm very grateful for you coming down to see me.
I feel like we need a special podcast charcuterie.
We don't have a green room budget for this project yet, but hopefully we will work on that and see if we can. Perks for the guests, a gift bag.
We're still on the granola bar project.
Little granola bars and things like that. We're working through it. Very grateful for you being here today. I know how passionate you are about the courts.
Yes.
And I know how important as part of your project and working with the courts is to make our courts more accessible to the average person, to provide information to them. And as part of that, you talk to a lot of people in your travels as you go around the state working for the courts and doing things, getting their opinions and their feedback about their observations about our court and how they interact with our courts. And through those discussions with folks, I know they always have a lot of questions. And so our focus today was, I told you to bring me some questions that they had, and we want to answer some more of them. So without further ado, I'll turn it over to you whenever you're ready, and you can fire away. And hopefully I don't screw it up.
Listen, you can't. You absolutely can't. One of the things I absolutely love about today's conversation is I believe so many people that I've talked to are just so genuine. They really signed up to be a public servant. And you certainly are a shining example of that. And so that's why when I said, you're just going to know all the answers. And I think we're going to be able to have a really thoughtful, incredible discussion today.
Let's just jump right in. I'm ready whenever you are.
So I have in my own brain called this 20 Questions with Judge Hamner.
I see a podcast title already.
Okay, what is one piece of advice you would give to law students who are waiting for their bar exam scores right now?
One piece of advice that I would give to law students who are waiting for their bar exam results: don't obsess. Some years ago, back in 2001 now, so what's that, 24 years ago, I took the bar. I was in their position and I was sitting around waiting for those results to be posted. Now, the nice thing about whether it's nice or not, the nice thing is that they set a date. This is the date that your bar results are going to come out. You don't have to look before then. You don't have to obsessively check something all the time to see if your results are in yet. It's coming out this day. But also having that end date, knowing that this is the time when all the hard work that I've put in for the last 3 years, I'm going to find out whether or not I actually get to be a lawyer or not. That's a very stressful time. I remember what it was like going through that, and remember waiting for, basically, you're going to log into a website and see whether or not you get to go forward on your path for the rest of your life, or whether or not you've hit a little speed bump and you've got to back up and do a couple of things over again. So what I would tell those law students and those folks who are anxiously awaiting bar results, try not to obsess about it. Because no matter what happens, whether you log into that website and you get good news or you get bad news, it is not the end of your journey. It is just the start of your journey. And regardless of how that comes out, you have a lot of journey left in front of you. So don't get too obsessed about what happens on that day when you log into the website.
I love that answer. I always feel emotional whenever I come across the videos of people gathering with their friends and family and they're opening those results. And so one of the things I would love to see this year is, as Missouri law students are opening their results, if you guys would tag us, tag Missouri courts, tag the Missouri Supreme Court in your videos when you create those. I can tell you, I absolutely would love to see those.
It's always so special and so exciting. And I was not one of those that wanted a big family presence. I think I opened my bar results in the privacy of my own home, probably in a dark corner somewhere, just in case things didn't go the way I wanted them to. I love that as well, because as a law student, to get to that point, to get an undergraduate degree and then to go on and survive 3 years of law school, it takes so many people.
Oh my gosh.
No one ever does it on their own. They have family, they have friends. And those folks that want to have all of them involved in that process. I love that so much. It's really exciting to see. So I would echo that request for those of you that are listening or watching today. If you're going to do videos, post them online. Make sure you tag us in those. Tag the Missouri Courts page, tag the Supreme Court page. We want to see those videos. We want to celebrate.
We will be celebrating.
We will be celebrating.
Yes, 100%. So on that vein, what advice would you give to young lawyers who have just passed the bar and they're looking for their first job?
You know, that's a very interesting question. I was just actually sitting down 2 days ago with a young lawyer who had just graduated law school, passed the bar, and wasn't sure what they wanted to do going forward. And they were looking for some advice in that. And what I would tell anybody who has passed the bar and gotten the results, congratulations, you're a lawyer. Now, what does that mean? What is the next step there? What I would encourage those folks to do is, number one, figure out what it is that you're passionate about. And don't limit that just to law. What in life are you passionate about? Because the thing is that's so great about the practice of law and coming through the legal profession is it is so broad. It is such a big tent. We have areas of the law that really cater to just about anything that you're passionate about. If you like science and technology, you can do patent law. You can represent companies that work in the tech industry. You can scratch that itch in the practice of law. If you really care about kids and taking care of children, we have areas of the law, juvenile law, family law, we have areas of the law where you can work with children and have that opportunity to affect their lives and be a positive influence. If you want to protect people's rights, and if you're really into the Constitution, you want to make sure that everybody gets a fair shake, we have criminal law, we have constitutional law, we have places to put whatever passion that you have and whatever that you're excited about. I promise you there is some place within the law that you can do that. If you're not sure what you want to do, and not uncommon at all for people who have just passed the bar to come out and say, I have no idea what to do now. I've worked so long to get this law degree and now I'm not entirely sure what I want to do with it. That is okay. It is okay not to know what you want to do. Find your passion and follow your heart, and I promise you there is a spot in the law for it.
And I would just clarify, I wrote young lawyers, and what I really mean is young in your profession, because a person can really go to law school at any age, at any season of their life, and so a person passing the bar can be any age, correct?
Absolutely. We have a lot of folks who come to law school that don't come right out of college and go to law school. They maybe go into another profession and have an entire career and decide at some point they want to come back and go to law school. We have more and more people that are coming to us seeking clerkships and coming into the profession who are older than the typical law students that you would see because they took a little bit longer path to get there. So that is becoming more and more common. And I would give them the same advice. It's a big tent. It's for the people right out of law school who came straight out of college, and it's also for the people who maybe did something else for 15 years and decided they wanted a new challenge. We've got room at the table for everybody, so don't be afraid.
You have worked with attorneys from all across Missouri. In your opinion, what are the pros and cons of being a big city attorney versus being an attorney in a small town?
It's an interesting question. Certainly one I do feel a little bit qualified to answer because my first job out of law school, I was a clerk in Jefferson City, but then my first law job where I was an actual lawyer, I moved to Kansas City. And so I actually just in a big city for 5 years in a firm there before I moved back home to Lake the Ozarks where I'm from and practiced in a small town for about 7 or 8 years before I became a judge. So I have had experiences in both the big cities and the small towns. And I will tell you, the benefits of practicing law in a big city are unquestionably the resources. There are so many lawyers around, and the bar associations, the groups of lawyers that come together, they're huge, and they have events and resources available for training and socialization. You have this big support system and this big net around you as a young lawyer when you come into a metropolitan area that you can lean on. You have the opportunity to make professional acquaintances and have friends. That's really the main benefit, at least to me, of practicing law in a big city. That's not to say that you don't get a good support system if you're practicing in a smaller town. That support system is just probably going to be a little bit smaller. There's not going to be quite as many lawyers, and it's going to be more dependent on who you're working with. I was the type that always rotated towards a firm where there were multiple lawyers involved because I wanted to have mentors. I wanted to have people who could teach me how to be a good lawyer because I knew a lot about the law, but I didn't know much about being a lawyer. I needed to learn that part of it. And I was blessed in the big city firm that I worked at and in the small town firm where I worked at that I had incredible mentors who were willing to take the time to show me how to do the work and how to do the things. And I'm grateful to them. So that's one benefit of kind of big city law. One of the downsides of practicing law in a big city is that it can be surprisingly isolating at times because there are so many lawyers, there's so many courts, there's so many cases, there's so many people. You may not run into the same people all the time. You may be meeting new people almost every single day and bouncing around. And sometimes, particularly when there are so many lawyers that are practicing in an area, it's not uncommon for lawyers to get into a niche and have one thing that they're really good at and they specialize at that. And that can be good or bad, depending on your personality and what you like about practicing law. I was always somebody that really liked the challenge of something new. I liked there being different things coming in the door and not really knowing what I was going to be doing from day to day, which is why I gravitated back towards moving back to a small town, because most of the time when you work in a small town, while there are lawyers that specialize in certain things, most of the time in a small town, you take whatever walks through the door because there are fewer cases, there are fewer clients, and you need all the clients and cases that you can get. So you're going to end up handling a dog bite case for a neighbor, and you're going to end up handling a contract dispute between two companies fighting over a bunch of money. You're going to handle somebody's upset that they didn't get their car back. You're going to handle a divorce. You're going to handle all of these various things if you work in a small town. And that variety, to me, I always really enjoyed about practicing in a small town, was not being pigeonholed into one thing and getting this wide breadth of different things to deal with. The other thing about practicing in a small town that is a benefit is while there aren't as many lawyers in the community, you're going to see these people all the time. You're going to work with the same lawyers and the same judges and the same clerks on all of your cases. And you're going to build relationships with those folks. And there's a real sense of community in a small town legal community, which I've always really gravitated toward and loved. Now, disadvantage of practicing in a small town is that lack of resources. As sometimes you would really like somebody who knows a lot about a particular type of law, but there's nobody around that does it, and that you don't have access necessarily to those resources unless you've made connections at a convention or some other thing that you've met some other lawyers at. So you always do have this struggle of finding resources to help clients who may have really specialized needs. Practicing in a big city, practicing in a small town, they both have their advantages and disadvantages. What I would tell you is if you're the type of person who likes to live in a big city and have a lot going on, you're going to like practicing law in a big city. If you're the type of person that likes a slower pace and likes living in a smaller town and getting to know everybody in town, you're going to like practicing law in a small town.
Wonderful. One of the things that I see talked about by attorneys who are especially early in their law career is the financial experience that they're having at a big firm or at a big city firm. But they also talk about the number of hours that they work, how extreme that is for those dollars. How do you find that compares to going to work at a law school for a small town? Is it quality of life extremely different on the financial side, or how do those levers get pulled?
I think that that's all going to be individual based on the attorney, based on what it is that you're searching for. And what do you as a lawyer want to do in your career? What do you want your career path to look like? And I guess the first thing that I would say is that the idea that you come out of law school and you start working somewhere and you're going to be there for the next 30 years, that idea doesn't really exist as much as it used to. That used to be the thing in the law. You came out of law school, you went to work for a firm, you stayed there until you became a partner, and then you retired, and that was the only place you ever worked. These days, it is much more common for lawyers to change jobs, for them not to end up in the same place that they started, for them to try different things on. And I tell law students who ask me, if you're not sure what you want to do in the law, don't be afraid to try it on. It's like a nice coat, put it on. If it's a little tight in the shoulders, or if it doesn't flow the way you want it to, take it off. There's lots of other coats on the rack. Put another one on, see if that one fits you better. There isn't the stigma that used to be attached to that in the legal profession like there was, because most people these days expect that you're going to bounce around a little bit in your legal career because of things that you talk about as far as a lot of jobs or particular jobs in this profession that are really hard. They're very intense and they're very stress-inducing. And sometimes people need a break from that. They burn out from those particular things. And so because of that, it's not unusual to move those things around. To your specific question that you asked about the difference in quality of life and the financial differences and those things, what I would tell new lawyers about your quality of life, you need to figure out what it is that you want out of your first 4 or 5 years in the profession. If your goal is to come out and make the most money in that period of time, for whatever reason that you would want to do that, you're likely going to gravitate more towards larger firms and larger cities because they tend to pay the most money to do those jobs. Now, there's an attendant trade-off for that. The old adage, nothing is ever for free. If you're being paid a lot of money, there's going to be expectations placed on you, and there's going to be work that needs to be done. And some people, that's what they want. They want to make money, and they want to come out and they want to work a good job where they're going to learn the ins and outs. And maybe they've always dreamed of being a partner in a big firm, and that is the path to do that. If you come out of law school and you're more concerned about your timing and living in a small town and being in a small community, there's absolutely nothing wrong with that either. Smaller firms historically have not paid quite as much as the firms in the big city, but you never know what you're going to find with respect to a commensurate hours, what they're going to expect you to do. So it's really up to the individual attorney to make that assessment for themselves. What do you want your life to look like in 5 years? Think about that question. You're going to get great training. Whatever path you take, you're going to work with incredible people. You just have to decide what you want your day-to-day life to look like when you make that decision.
Thank you. I'm going to switch gears for just a second.
Sure.
Can you help us understand how the courts in the United States protect citizens' freedoms, rights, and liberties, and how that approach may differ? What I'm really looking for is how our approach in the United States to protect our citizens' freedoms, rights, and liberties in general from other countries.
I can try to speak intelligently about that. I have not personally had a lot of experience with legal systems in other countries. I have certainly never practiced in another country. I've certainly had conversations with judges and lawyers who work in other countries about how their systems work and how they may differ from that in America. But I certainly would not claim to be an expert in the laws or the procedures or how other countries work. But I do know that in the United States, our court system plays a very important role in protecting the rights of our citizens and those things that are protected by the Constitution, both of the United States and the state of Missouri. We deal with a lot of those issues on a day-to-day basis. Issues affecting people's freedom, people's liberty, people's rights to be safe in their homes, people's rights to do with their property as they wish, subject to certain regulations that we've agreed to and legal limitations. So we, of course, play a big role in interpreting the Constitution and interpreting the laws that are passed by the legislature and interpreting the rules that may get adopted by various organizations for how it is that we're all going to live in harmony. When you have this many people crammed into one place on the planet, everybody has their expectation for the way that their life should be and the way that society should operate and how things should work. Without those rules and those guidelines in place, then we don't have any way to figure out a way to live together. We certainly don't want everybody just doing whatever it is they want to do, which is why we adopted the laws and the constitutions in the first place, so that we had a set of guidelines that we all agree, look, for the most part, you're going to be allowed to do what you want to do, except for these set number of things. And so with those set number of things, that's where we go. These are the things that we've agreed on. Legislatures passed laws, the Constitution's been adopted. These are the things that we all agree that we're going to follow these rules. And a lot of times there's a dispute. What does it mean to follow those rules? And that's where the courts come in. And so if you, as a citizen, as somebody who has rights that are protected by the Constitution, by the laws, if you have questions or about whether your rights are being protected, if you think that something is happening that is against the rights, you have the right to come to court and have that issue addressed. You have the right to come to court and have a judge or a jury make a determination as to whether or not your rights are being affected. And that is a wonderful resource to have for people. I do know that there are places in this world where folks don't have that. They don't have a place where they can walk in and say, hey, my rights are being violated, do something about it. Not everyone has that. I think that me being a judge in this system and a lawyer in this system for a long time, I think we have a fabulous legal system here. It's certainly not perfect, and I would never advocate that it is perfect, but it is open, it is fair, and we are always looking to improve. And I think when you have those three things, you have the basis of building a legal system that can really change people's lives and really protect them.
Thank you. In your experience, other personality traits or characteristics of a person that you think make a person just a great attorney or a great judge? And conversely, do you think that there are personality traits or characteristics of a person that cause them to have a harder time? And where I'm really going with this is not to judge anyone who's currently in this profession, but for someone who's thinking about a career change, and that maybe they're thinking, I like watching Law & Order SVU. Maybe I'd be good at that. Where that person could really do some self-examination, determine whether or not they feel like they have those traits and characteristics, to determine whether or not at the end of that course period in law school, and then actually doing the job every day, they would actually maybe like the job and be successful in the job.
I don't think, and let me preface this by saying that, and the reason why I'm going to give this answer is because I feel like I'm a bit of an exception to the rule. I don't think there is any particular trait that you could have or not have that would prohibit you or be a slam dunk for you to be a lawyer. Because I think that any person, if you're passionate about the law, if you have a commitment to it, and it's something that really interests you and you want to practice it, I don't think it matters. I think that, again, we have a big tent, and no matter what your personality traits are and whatever things that you're doing, we can find a spot for you. You can find a spot under the tent to do something in the profession of law. Now, with that being said, there are certain jobs and certain things that you can do within the law that you can't be a little bit more attuned to or not attuned to based on how your particular personality is. I knew a lot of my classmates in law school who were not big people persons. They did not like interacting with people and working with them. We have spaces in law for that. You can go into transactional law. You can go into various things where you're not in a courtroom every day. You're not meeting with clients all the time. We have places for that. There's a lot of people in law school who want to be big-time litigators, the courtroom attorneys who go to court and say, I object, and are trying all the jury trials and doing all the things. And those are really great jobs, and it's really fun. I was a litigator for a long time. I have been a trial judge before I became an appellate judge. But those jobs are very high stress. There is a lot of stress that comes from working those types of jobs. And it comes and goes in waves. It's not always stressful, but there are times that the most stressed out you will be in your life is when you are getting ready for a jury trial, a 7-day jury trial that's starting the next week, and you haven't got everything together yet. There is no more stress than that. Or trying to get through a trial and waiting for that verdict to come back. It can be very stressful. Think about that before you launch into your career. If you're someone who is adverse to stress and you don't handle stress well, maybe litigation isn't necessarily the thing for you. I say all that to loop back to the point at the beginning that don't let who you are or who you perceive yourself to be a barrier to working in the law and coming into the law, because we have places for everybody. I've been a judge now for about 10 years, and all of the judges I had met before I became on the bench, and really before I got to know them better, had all been esteemed lawyers and well-practiced, and had all gone to law school and had great careers and were well-respected and had done all these great legal things. And I had sometimes questioned whether or not I should be a judge, because while I went to law school and I had a career and did all these things, I was always weird too. I had all these weird hobbies. I drove race cars. I was a mascot. I sang in a band. I've had many people over the course of my career say, I can't believe you're a judge. You don't seem like a judge. You're not the kind of person that we would see as a judge. I tell them all that same thing, that is, there's room for all types of people in the law. It's not one type of person sitting behind a great big oak desk with glasses on who's been in an office for 30 years. We have room for all sorts of people in the law. Anybody can be a judge. Anybody can be a lawyer. That's the great thing about Missouri with our Missouri plan. And so what I would tell people is that don't worry so much about what your character traits are as far as prohibiting you from becoming a lawyer or being successful in the profession, because I promise you, we can find a place within the profession that you can be successful, no matter what your character traits are.
On the appellate court, you sit with 2 other judges, right?
Sometimes.
Okay, so where I'm going with this is there are times you and some other people, the other judges that you work with, may have to come together on a decision. And you are all different people with different life experiences and maybe different perspectives, even though you're all reading the same law and you've all heard the same facts before you. What advice would you give to someone who's in a work situation, who is on a team and they are needing to come together with their teammates and come to some kind of consensus, whether it's agree to disagree or some way to just come together based on the facts in front of them and a common goal and be able to just cohesively move forward. What are some of the things you tell yourself? How have you gotten yourself to these places? And how do you find a way to stay true to your own beliefs when you don't agree, but be a cohesive team and find a way to move forward?
That's a great question. I work on the Court of Appeals here in the state of Missouri. We have 3 different districts that are in Kansas City, St. Louis, and also here in Springfield. All of those courts have multiple judges. We here in the Southern District, we have 7 judges. But when we hear cases, we hear them at panels of 3. So 3 judges hear a case, and then an opinion will get written, and then they will all vote on that. And a lot of times we're in agreement, but sometimes we aren't. Sometimes if a case is particularly difficult, we'll hear the case as a court, what we call en banc. So all 7 of us will sit on the case, and we'll hear it all together, and we will all make the decision as to what the outcome is. Now our Supreme Court, which is the next appellate court out from us, they always sit together. All 7 of them all together for every case. So they don't do the panel of 3 thing, regardless of whether I'm sitting with 2 other judges or whether I'm sitting with 6 other judges. It is not uncommon for judges to disagree about a particular outcome in a case or how a particular piece of law should be interpreted based on the particular facts of a case. And that just comes with the job. You expect that there's going to be conflict, there's going to be differences in opinion as to how particular things should be ruled or should be come down. That is because the law is a living, breathing thing. It's always changing. The legislature's always changing the law. And the facts of every case that come before us are always different. And figuring out how those facts fit in the box of the law can be a challenge. Just like there's hundreds of different ways you can pack all of your boxes in a car. The law is kind of the same way. When you take the facts of a case, there are many different ways you could pack those facts in the box that is the law for that particular case. And so oftentimes intelligent people will have disagreements about what a particular piece of law means or how those facts in that case will be applied to that law. I think the most important thing when you are working with other people where you have to come to a consensus, where you may have disagreements over the path forward and how it should be worked out, I think the most important thing to remember in that environment is that when people disagree about things of that nature, academic things or legal things, how these things should work, it's not a disagreement with who you are as a person. It's not them saying, I don't agree with you, I think you're a horrible person. Because I think sometimes people feel that way. When they give an idea and somebody says, no, I don't like that idea, instead of just saying, oh, they didn't like that idea, they say, oh, they don't like me. They don't like what I offered, and so therefore they must not like me. And what that does is it leads to people making academic disputes. And make no mistake about it, when we're dealing with the law, as important as these issues are for folks, these tend to be more academic type disputes, but they are not personal disputes. And you have to work so hard when you're working with other people to make decisions of this type to not make any conflicts personal, because it is completely acceptable for people to have different opinions, to feel differently about the way a sentence reads or a way a particular paragraph, what it all means. We can all have different interpretations of Shakespeare or of any other book or any other thing that we read. And just because my interpretation of what Romeo or Juliet means is different doesn't make me a bad person, or doesn't mean that I reject who you are as a person, because your opinion is different than mine. And if you can keep that personal animosity out of whatever conflicts you're having at work and just focus on the question that's in front of you and coming to the right decision based on the information that you have, you're going to be in a much, much better position to find common ground, to figure out a way to answer the question in a way that it works for everybody and that you can move forward. Now, my job is a little different than other people's jobs, in that if you have conflict with people at work, there's only one decision. That decision has to get made. Somebody's going to make it, and that's the way it's going to be. In my line of work, even though we work very hard to try to agree on everything that we put out, if I don't agree with something, if I really don't agree with something, I don't have to vote for it. I can write my own opinion and say, you know what, I know what the other judges on the panel are saying and they're putting it out as their opinion. I disagree. And here's why I disagree with it. And so I have the ability to communicate if I feel strongly enough about something that it's not right. I have the ability to communicate to people that I don't agree with it, and I don't have to agree to it. But I think that while it's not uncommon for judges to do what we call dissent in cases, when they'll write a separate opinion and dissent on those issues, that's a beautiful thing about our job is we work really hard because to speak with one voice, multiple judges saying this is the way it should be, is helpful for litigants. It's helpful for trial judges for them to know what we believe the law is. But it's also helpful at times for us to say, wait a minute, we don't agree. That's the way it should be. And here's why I don't think that's the way that the law should read. And because of that, as judges, we do get the ability to voice our opinions, even if our votes aren't going to carry the day and we're not going to necessarily be on the winning side. So our situation is a little bit different than your typical work environment where a decision is going to get made and that's going to be the end of it.
We talked about stress a little bit earlier. Many professions, from judges to law enforcement, teachers, medical, healthcare providers, folks who listen to other people's stories and are present for some of the hardest moments in a person's life. That carries a weight to it. We use phrases like, how do you turn it off? There really is no turning it off. And so recognizing that for a person who's in a similar profession, where maybe they're also carrying some heavy moments that they've shared with another person walking this earth. What are some ways that you have found, either through your own experience or just through talking with colleagues, that you might just pass along that is helpful to maintain a healthy life balance, healthy mental state, and healthy relationships with other people who you may or may not, because of privacy concerns, even be able to talk to about what happened during your day?
That is an excellent question, and certainly one that I have thought about a lot because of my particular situation, and I'll explain. Let me resolve this by saying that I speak about these types of issues and these types of topics solely from my experience with them. I'm not a psychologist, I'm not a psychiatrist, but I can tell you as an attorney and as a judge, having experience with seeing incredibly difficult cases come through my court, that the concept of what they would call transferred trauma is real. Every time a witness comes in and tells their story, everyone in the courtroom is affected. From not just the judge and the lawyers, but from the bailiffs, from the people sitting in the gallery to the clerks and the court reporter, who are all there, who have to hear these horrible things that can happen to people. And a little piece of that gets left with everybody who participates in that process. And so making sure that people are taking care of themselves and their emotional well-being is something that is very important, certainly in our court system, but throughout the legal profession, because it is a high-stress environment. You do deal with a lot of things that the average person doesn't have to deal with on a daily basis. You have a lot of experiences that occur in your life, but as a lawyer and as a judge, you have hundreds of people who come into your office who dump all of those experiences on you. So it's not just one person's experiences, it's hundreds of people's experiences. And that is in addition to whatever experiencing you're having in your own life. Lawyers and judges, we're all people too, and we have our own lives, and we have our own stressors in our own lives. And so it can be a lot. It can certainly be a lot. I don't necessarily know what I would tell folks as far as whether I would have any tips or advice for how they should deal with it, because the fact of the matter is it's completely dependent on who you are. It's completely dependent on how you process it and how you get rid of it. I do think it's important for folks to find a way to get rid of it. When you have a lot of stress, when you have a lot of things that get dumped on you, and you have experiences that are hard to listen to and they get burnt into your mind and you have to remember them, you have to find a way to unload that. Whether that is in just taking a run with your AirPods jacked out to the max with some music that you love, whether that is lifting weights, reading a book, or painting a picture, or going for a swim, or playing video games, or watching TV, whatever it is that you have to do to release that stuff. That's what you need to find a way to do. Because I do promise at some point during your journey as a lawyer, as a judge, just as being a person walking this planet, you're going to have a situation that's stressful. You're going to have something unfortunate that's going to happen to you or someone that you love, and you're going to have to deal with it and process it. And those of us in the legal profession, lawyers, judges, we get a lot of that. And so it's important to find out what works for you and have a support system around you that knows what works for you and that can help you process that. I don't feel like I answered your question.
I do think that you answered it, because it is important that each person recognize that it is valid. What they're experiencing is valid and that it is common. And I think because sometimes you can't talk about it, it can feel very isolating. And that in itself, again, not a psychologist, anytime we aren't able to talk about something, it almost creates its own injury because it feels very isolating and kind of like operating in a silo. And so we can start to tell ourselves stories about how maybe we're the only one struggling with things. We're the only one experiencing this way. Everyone else is doing okay and we're not, which is completely not true. Anyone who is doing a good job at these things, which are caring for other people, any of these professions are caring for other people in a highly competent way, healthcare, the law, you have to have a very high level of intelligence. But to do them well, you also have to have a very high level of care. And so it's going to impact you.
And that care is not just for the people that you're working for and the people that you're working with, but it's for yourself as well.
Right.
And that's what sometimes I think lawyers and judges particularly will overlook, because I can promise you, every judge I have ever worked with, every lawyer that I have ever worked with, they care about the people that they represent, they care about the people that they're working with. Now, you may not agree with decisions that they make during the process or how they do a particular thing, but I promise you, judges and lawyers care about the people that come in front of them, and they're trying to do their best. And sometimes because of that, they forget to take care of themselves. And so I always try to emphasize, don't forget to take care of yourself as you're going through this process, because you are absorbing a lot of things that you wouldn't ordinarily have to absorb, and you have to figure out a way to deal with all of that.
Yes. Thank you for that. Find my glasses back here. Have you ever, okay, this is juicy.
Oh, that's scary.
Have you ever found yourself wishing you could just speak to someone as a judge from the stand? This is when you were a circuit judge. Have you ever just found yourself wishing you could just ask questions that the attorneys aren't asking, because you can see maybe glances between people in the courtroom that they aren't catching, and that there's something amok that they aren't seeing, and you just want to dive in, swim to it, and say, pardon me, and just ask different questions? And if you do see that, can you do it?
First off, it happens all the time. As a trial judge, absolutely. Because when you're sitting up there in that chair, you're overlooking the whole courtroom, and you see a lot more than people think. And I like that people don't necessarily know that I'm seeing everything, because you catch a lot more things that way. But sometimes people get confused about what a judge's role is in the process and what we do. I would often tell people who would come into my courtroom, and they would say, Judge, what should I do? Should I do this, and that, and the other? And I would always tell them, look, I'm the umpire. I call the balls and strikes. I don't tell people what pitches to throw. That is not my job, and we're not supposed to do that. One of the hardest things as a trial judge, to me, one of the biggest adjustments I had, was that we are restricted as judges to the evidence that is put in front of us by the parties. That is all we are allowed to consider within the four walls of our courtroom to make a decision in a case. Whatever they put in front of us, that's all we get. We don't get to go out and do research. We don't get to go to Google and find other stuff. We have to decide our cases based on what it is they give us, and only what they give us. And the fact of the matter is that in a lot of cases as a trial judge, you find yourself making some of the most critical and important decisions in people's lives based on about 25% of the information that you wish you would have to make that decision, because all we get is what they give us. That's all we get.
So
Yes.
you can't ask the attorneys, because in the movies and on TV, they ask them to come into chambers and they give them a good talking to.
Those are usually more disciplinary. You're racked it up in my courtroom, don't do that again. We are not allowed as judges to be advocates for either side, except in rare circumstances. We are not supposed to interject ourselves into proceedings. It is up to the lawyers and the parties to try their cases, to put on for the judge, for the jury, whoever it might be making the decision. It is their responsibility to put on for us what it is they want us to base a decision on. And as judges, we are not supposed to, in most circumstances, weigh into those circumstances. Now, that being said, when I was hearing cases, what we would call a bench trial case as a judge, no jury, just they're trying the case to me as the judge, and I'm the one making the ultimate decision in the case. In those scenarios, I have occasionally asked a question. If there's a really important issue in the case that for whatever reason, neither of the lawyers has asked a particular witness about, that's like a key thing, sometimes I would just be saying, I have to know the answer to this question, so here it is. We as judges, and I think that this is pretty uniform for most judges, my experience has been judges are very loath to do that, because that isn't our role. What you don't want is somebody leaving the courtroom after a decision has been made and thinking that the judge tipped the scale, the judge did something to turn the evidence against them. that there was some reason that they lost other than simply on the facts and laws presented to the court, they were wrong. We don't want people to do that. And so because of that, as judges, we try not to get involved in the presentation of the cases. A lot of times, I will tell you, in my experience, and I think other judges would tell you this too, a lot of times, if we rule against a particular party, particularly if it's a plaintiff, the person who had the burden of proof to put on a case, if we rule against that party, we're not necessarily saying we thought they were wrong. But what we're saying is that you had this burden to put on X amount of evidence to prove your case. You didn't get to that threshold. And that doesn't necessarily mean that we didn't agree with the position you took, but you had the burden to put on this amount of evidence, and you didn't get there. And so I have to rule for the other side. That's the law.
Following up on that,
Sure.
what happens if a judge feels like justice is not being served in a case? When you as a judge just feel like for whatever reason, there is a clear miscarriage of justice happening, do you just continue to accept the evidence? What do you do?
I think it really depends on what exactly you consider a miscarriage of justice, depending on what's going on. Particularly in criminal cases, the court does have some affirmative obligations to step in. If we see violations of the Constitution occurring, if we see rights being violated, we have an obligation to step in and moderate that to some degree. As in criminal cases, if you're facing jail time or felonies, you have the right to counsel. And that counsel has to perform to a particular standard. And if it doesn't go your way and there's an appeal, you have the right to ask the court at some point in the process to look at the performance of your attorney and whether or not they met that minimum standard in dealing in a criminal case. You don't have that in civil cases. There's no such thing as ineffective assistance of counsel in a civil case because you are hiring your own attorney. You are choosing your own lawyer. And because you have done that, there's no constitutional right to an attorney. Every judge that I have ever worked with been steadfast and hard about making sure that the rights of the parties that come in front of them are protected, because that is one of our primary functions as a court, is to make sure that their rights are protected. As judges, we do our best to speak up whenever we feel like we can to address issues that may be going on, but also understand people have the right to make their own decisions in cases, and whether or not we agree with them, they can pursue a strategy, they can ask for relief, they can do the things that they want to do. Whether or not I as a judge agree with them, they're allowed to do that. And if that ultimately doesn't work out for them, that isn't necessarily the type of thing that we would wade into the middle of and fix.
What are some of the things that you have observed that courts are doing today that are really improving access to justice?
I think that the biggest thing that courts are doing today to improve access for folks who have maybe traditionally struggled, we have really made great strides. I credit the Supreme Court and our Office of State Court Administrators and the legislature for making money available and making it a priority to make our courts more digital. And because that, I think above everything else, is really improved access, be it through the use of a virtual hearing, which is now allowing people to appear virtually in certain cases for certain proceedings on a court-by-court basis. But having that as an option has greatly increased folks' access who may not otherwise be able to get to the courthouse. Increase in the use of pro se forms, and the pro se forms that are being promulgated by the Supreme Court and by courts around the state for people who may not have access to a lawyer or may not be able to afford to hire a lawyer to handle cases. We now make some resources available to them in multiple languages to help them with their cases if they may not otherwise be able to file it. Judge Moon mentioned in a podcast that you may or may not have seen at the time this airs, but there are also other technological advancements. The municipalities in Kansas City, St. Louis, and St. Charles are developing kiosks whereby people can come in and utilizing the kiosk, it can help them put their case together and actually generate a pleading for them and help them file it. I think that Open CaseNet has been huge, making the information available to the general public. While from the judiciary side and from the lawyer side, there's been some growing pains with that and some heartache because of confidential information. But the concept of folks being able to be in their homes and find out what is going on with their case, that's a huge leap, a huge increase in access for them to be able to get to those things. Now, is everything perfect? Of course it's not. We're always working towards trying to make our courts as accessible as possible. And those efforts are going to continue. But I really have been very impressed by the technological leaps that we have made as a judiciary in the last 10 or so years to improve access.
I've seen some things floating in my purview about Missouri's juvenile law recently changing about the age, something about the age of a juvenile.
Raise the age.
Yeah, raise the age, yes, thank you. And I was wondering if you could help myself and maybe other Missourians understand a little more about what that is from a legal perspective.
Sure. Raise the age was the common name given to a bill passed by our legislature, and I don't remember what year it was. I think it's been 2 or 3 years since that bill was passed. Before that bill was passed, you were a juvenile. If you were 17-year-old, you were considered a juvenile in the eyes of the law. And what that meant is that if you committed an offense that would otherwise be a crime, that offense, as long as it was not traffic related or fall into some other exceptions, that offense would be handled by the juvenile court. And the reason for that, and this system was set up a long time ago, the reason for that is because there had long been an embrace or acceptance that, juvenile brains are different than adult brains. We all can testify to that, as we did some stupid things. And the creation of the juvenile system recognizes that their brains weren't developed to the point where we could trust that they were making good decisions. We wanted to focus more on working with those kids and providing them guidance so that mistakes that you make as a kid don't develop into mistakes that you make as an adult, where they can suffer more serious consequences. So it used to be 17 until the new law was passed. The new law raised that age to 18. Now individuals aren't subject to the exclusive jurisdiction of the juvenile court, meaning this, again, if they commit what would otherwise be a crime, they have to start in the juvenile system. Now that doesn't mean that they can't end up in the adult system. We have the ability to certify juveniles as adults, to stand trial as adults for particularly heinous crimes and offenses, and that still does happen. But for the most part, the concept is that kids make stupid decisions sometimes, and we don't want to mess up a kid's entire life by pinning them with a criminal charge when they're under 18. We only want to do that in certain instances. As to why the change was made, we raised the age from 17 to 18. I'm not the legislature. I don't know exactly why they agreed to sign off on this. My understanding is because the science changed. And so we wanted to give that additional period of time to give the chance for the juvenile system to work with those kids, to try to get them on the right path before we saddle them with a criminal conviction that can affect their ability to vote, that can affect their ability to hold a job, that can affect their ability to get into school and do all these other things before they even get started. It doesn't always work. There are kids, unquestionably, who go into the juvenile system and come out and end up committing crimes, and they end up in the adult system. But there are kids that it works for. That is kind of the rationale, I believe, behind why the age went from 17 to 18 and how it proceeds now.
Thank you for explaining that. Is there a youngest age that a child can actually be sent to real jail or be certified as an adult?
There is.
That's a horrible thing to think about, but
Sure.
That made me kind of think about that when I was thinking through these questions.
And it's a perfectly logical question and something to be curious about, absolutely. We are not allowed to put someone who is younger in an adult detention facility unless they have been certified as an adult, charged as an adult, tried as an adult. So if a juvenile, and you commit a criminal offense, you're going to go to a detention facility. You will not be locked in jail with all the adults. You will not go to a state prison or anything like that. Now, as we said, for certain instances, you can ask the juvenile court to certify a juvenile as an adult and then punish them as an adult and then treat them as an adult going forward. And you asked about age limits for that. A particular fellow seriously committed to something and knew what they were doing, think that it's appropriate to certify them as an adult and try them as an adult. That's not really in my bailiwick. And fortunately, as a circuit judge, never had to deal with a case whereby a juvenile was certified as an adult.
Can you help me understand what pretrial services are? Are pretrial services like probation, drug court, veterans court, those all fall under pretrial services, or are they separate buckets of things?
Separate buckets of things. Okay. Separate buckets of things that deal with similar issues. When you're talking about pretrial services, what I understand that to be, and I think most of the folks in the legal profession would understand that to be, is if you are accused of a crime, an arrest warrant has been issued or charges have been filed against you, the court has to make a determination in the first instance, if you've been charged with a crime, as to what level of danger you are in the community, as to whether you're entitled to bail at all, to be out while your case is pending, whether there should be any restrictions on you for the safety of the community or to ensure your appearance in court. So those are all determinations that get made in every single criminal case. The court has to make that determination as every single defendant that comes in front of it. The courts across the state all have various ways that they do that because it's very resource heavy. And so they've all kind of figured out their own ways to do it. Some jurisdictions utilize what we would call private services to monitor the defendants who are on bond. Some jurisdictions have money available. They pay for the monitoring services that are covering these people. And so what pretrial services are really focused on is the idea of services in place that are going to be utilized by the court to help make these determinations as to how we set bonds and to how we figure out what restrictions we place on defendants while they are released pending trial, and provides hopefully a mechanism to pay for some of those services, as far as if someone needs to be monitored by GPS, if they need to be drug tested. All of those things now are handled in vastly different ways across the state depending on what resources are available. The goal, at least the hope of, I think, when people talk about, well, we need pretrial services in Missouri, is to try to make that process more uniform and to have a process that courts in areas that maybe don't have the resources that other areas do, give them some resources to help them fund and provide for supervision of people who are awaiting trial. You talk about veterans court, treatment courts, and all those things. That is on the probation. That is all on the back end. You have pled guilty in most instances. After you've pled guilty, it's a condition of your probation. Probation is that thing you're on after you have been convicted of a crime. And it's the
Forgive
thing.
me for not knowing that.
Sure. It's a common mistake to make. And treatment courts and veterans courts and probation all monitor people same ways. They may put GPS on people, they may drug test people. It's just at a different stage in the proceeding than we're talking about when we're looking at pretrial services.
So pretrial services is, how do we evaluate? I want to make sure I get it in my brain, because I did a lot of reading on it and I still felt a little bit confused. So I just thought I would ask you.
Sure.
So pretrial services is before the trial. The person has not been found innocent or guilty.
Correct.
They have just been arrested. They've been charged with something. They've been put in jail.
Sometimes, not always. Sometimes,
Well,
in the vast majority of cases, charges get filed and a defendant, there may not ever be a warrant issued, ever set foot in a jail until such time as their case is resolved.
And pretrial services would still be utilized in this situation?
Pretrial services would still be utilized in that situation. Currently in our system, as we determine how bond is set, it puts burden on a lot of people. The sheriff's department, prosecutors, defense attorneys, the court. They all have to provide information to the court so they can try to figure out whether someone needs to be restricted while they're on bond, whether they're a threat to not appear in court, or whether there's some sort of danger to the community. Those are the two things you're looking at when you're setting bond. Pretrial services is to try to provide courts a mechanism that doesn't involve having to get the prosecutors involved, to have somebody whose job it is for the court to put that information together and make a recommendation to the court as to what the bond should be. And really the hope that there was utilizing these things, that maybe the decisions with respect to bond are more uniform across all the cases.
That makes sense. So the coordinator,
Mhm.
and they gather all this information and get a consistent level of data that they can then provide to the judge. And then the judge can make that determination.
And it could be one person or several people,
Or a
depending on the
team of
assignment,
people.
depending on
Yeah.
the size of the
A
jurisdiction.
team of people.
But yes, the concept is the same. It's a person who, for folks that might be familiar with a probation officer, and you meet with them from time to time, and they gather information about you, monitor your progress and how you're doing. The concept of pretrial services is the same, except it's on the front end. If you're out on bond, you would be assigned a pretrial service officer. You would check in with them periodically. That pretrial services division would help the court in monitoring those folks who are out on bond, make sure that things are being done the way they're supposed to be done.
I can see how that would greatly improve consistency. It's like 3 people here and 1 person here and 2 people here and 10 people here. They can imagine that they understand and have a pretty uniform set of rules and training and things that they undergo, so that's pretty level set, right? That makes
Right.
sense.
Yep, that's exactly right.
If someone's coming into court to represent themselves, I would imagine this would be like in a circuit court across the state. What are 3 key phrases that they're probably going to hear in court that they may not have ever heard before in their life that they should probably know?
Oh, geez, that's a really good question. 3 phrases that they've probably never heard. Because most people have heard the things you'd expect them to hear. I object. Objection. People, I expect, have heard that phrase a lot, but they may not know what that really means.
Right.
If you hear the word objection, that is an issue that means that whoever's making that, signaling to the court, hold on, I think something is wrong. There's a rule that's being violated. Something is happening in the procedure that isn't correct. And I would like you as the judge to know that and give me a ruling as to whether or not a rule is being violated and something happened right now.
So if I'm a pro se litigant, I want to say I object, it's not because I don't agree, it's because a rule of the court is not being followed. So if I'm going to say I object, do I need to be able to say what rule I think is not being followed?
Yes.
Okay.
Objections are purely legal questions.
Right.
It can't just be, well, I don't agree, they're lying. That's not a legal objection. Legal objections are based on procedure. They're based on the rules that are in place. That is certainly one of the challenges for pro se litigants. Preparing your pleadings and doing all that stuff is one thing, but if you get to the point where you actually have to have a hearing and you actually have to have a trial, as judges, we are required under the law to treat pro se litigants just like we treat other attorneys. And so you have to follow all of the same rules that I would expect an attorney would follow. That includes rules related to evidence and all the various things. And knowing those rules and what evidence you can use and what evidence you can't use. If there are objections that are made, I have to follow the rules. And so you either follow the rules or you don't. And then the worst part of it is because I'm not allowed to be an advocate. I'm the umpire. I call the balls and the strikes. If somebody objects to evidence you're trying to put in and I sustain the objection, you say, well, what did I do? What am I supposed to do? I can't tell you what you are supposed to do because I'm not allowed to help you. And that is a source of frustration for pro se litigants, which I understand and I get, but at the same time, I hope they understand why that rule exists.
Thank you. As a point of reference, the Missouri Bar has a glossary of legal terms that is really extensive on their website. And they've got a lot of resources for pro se litigants, and also the Missouri court website, great videos to help prepare people if they're going to represent themselves.
That's excellent. I have not reviewed that glossary, but knowing the work that the Missouri Bar does, they do good work.
It's really extensive. My last question before we go into the lightning round is, across the country, the courts are having really great conversations about technology. I think a lot of industries are having conversations about technology today, and even AI. Can you help me understand where Missouri fits into that conversation? And how do you see technology shaping the work of the courts and the law in the future?
Well, I guess I would preface this answer by saying I have my own opinions on where all this is. I don't speak for my court or any of the courts, the judiciary, and I will tell you that AI is an issue that our court system is looking at very carefully. Groups that already within the judiciary and within the Missouri Bar looking at AI, learning about AI issues, and focused on exactly what you asked. How is this going to affect the practice of law going forward? How are we going to see this in our courts? What are the dangers of this? But also, how can we use it to help? Is there a path through which we could utilize some of these tools and resources to help pro se litigants or to help other people have access to our courts? So it's really a comprehensive look at what this technology is. You ask kind of where Missouri fits into all this. We fit where everybody does. It's coming. We have no way to stop it. There will not just be AI in the 49 other states of the United States and no AI here. It's not going to happen. Like all technological advances, when we had a gas-powered car, computers, MRIs, X-rays, the technology just explodes and then everybody needs it and then it just washes over. We have to figure out a way to deal with it. I will tell you that in my experience, our legal system has in the past often been slow to adapt to technology, because ours is a system that's based on precedent and decisions that are reviewed over many years and cases that come up, and that's how we build certainty in our case law and things. Technology doesn't work that way. Technology moves a lot faster than that, and a lot faster than the courts traditionally have. So I'm very encouraged that the Missouri Bar and everybody has stepped forward and are looking so hard at this issue of AI and are considering these issues so promptly as this technology is developing. That can only help our courts. That can only help the people that come to court. I am somebody that's always been an early adopter of technology, so I see both the benefits and the pitfalls of potential AI incorporation into our judiciary. We're talking about that in committees that I'm on and groups that I'm involved with through the judiciary and through the bar about the import of technology. It has the ability to provide assistance to pro se litigants. It has the ability to provide assistance in helping to administer cases, to organize our dockets and cases. There's a lot of functionality that could be used to help provide information to the public about how our courts operate, the way we do things, and why we do things the way they do. There's a lot of positive impacts that can come from AI that every business, that every profession and occupation can provide, not just the legal profession, but you're going to see it everywhere you go. AI can be utilized to improve things. But particularly from the legal standpoint, there's also pitfalls that we have to be careful of, because AI can create things that don't exist. with the readily available use of tools and technology, they can be utilized by anyone to create things that aren't true, to create things that don't exist, to make it harder for courts to do the jobs that they do, which is sift through all of the information that gets provided to try to get to the truth. And AI has the potential to make it harder to figure out what's true and what's not. As a court, we have to figure out how we're going to address those issues as they come up, and what can we do on the front end to try to get ahead of those issues, to make sure that we are armed with the tools we need to sift through those issues as they get created. Regardless of how you feel about AI, that train is coming down the track. We need to be prepared to deal with it.
Lightning round.
Lightning round question. This is my favorite part of our last one.
I know, lightning round. What's the best piece of advice you ever received?
To be yourself.
Great. What book, movie, or TV show do you think actually gets the legal system closest to right?
That's a really interesting question. I think a lot of the movies and TV shows get parts of it right, but I've never seen one that I thought got all of it right.
Then that's your answer. Awesome. Coffee or sweet tea or something else?
Oh, I'm a tea. I don't really do coffee.
Sweet or unsweet?
Unsweet usually.
Okay. If you could instantly master one skill outside of the law, what would it be?
Playing guitar.
I was going to say, and not guitar.
Oh.
So not guitar, because I know
you knew me too well.
I should have said that.
I love to play guitar like Jimmy Page. But I would want to master outside of the law that's not guitar.
That's not guitar.
Painting.
Ooh, like to paint people or things or nature?
A physical artist. I don't draw, I don't color, I don't do all that stuff because I'm really bad at it. But I've always really kind of creative, and I like to express myself through music in various ways. I think that would be a natural extension of that, and I think it would be a wonderful outlet if I could do it, but I'm terrible at it. My stick figures are terrible, so it's not even close.
That's so cool. What's one Missouri tradition, food, or place you think that everyone should experience at least once?
Tradition, food, or experience that everyone should experience, just Bagnell Dam, which is the facility that created Lake of the Ozarks. They dammed up the Osage River, created Lake of the Ozarks. Various times throughout the year, they open the floodgates on the dam. There is an incredible overlook right below the dam where you can park your car and walk out. When they open all of those floodgates and that water is coming out of there, it is a sight to see with the current of the river and everything else going on. If you've never done that, I highly recommend take that trip to Bagnell Dam sometime when the floodgates are open and see it in person. It's really impressive.
Last question. In one word, what do you hope that people think of when they think of Missouri's courts?
Fair.
Excellent. I told you, I knew you were going to know all the answers.
Well, and again, I want to thank Michelle, our producer, for being here with us today. We hope that you have enjoyed listening to the podcast, maybe learned something you didn't know. If you have questions that you would like to have answered on a future podcast episode by me or one of our guests, comment and let us know. We've enjoyed having you here. We've enjoyed being here today. With nothing else to discuss at this time, this podcast is adjourned.